On June 15, 2012, President Obama ordered his administration to stop the deportation of young people under certain circumstances who came to the U.S. as young children. Under this new policy, people younger than 30 years of age who came to the U.S. before the age of 16, who posed no criminal or security threat, and were successful students or served in the military, can get a 2-year deferral from deportation. As stated in the memorandum dated June 15, 2012 from the Department of Homeland Security, which is also known as DHS, DHS will exercise its prosecutorial discretion when enforcing the nation's immigration laws against certain young people who are brought to this country as children. The following criteria must be satisfied before an individual is considered for this new policy: came to the United States under the age of 16, has continuously resided in the United States for at least 5 years preceding June 15, 2012, and is present in the United States on June 15, 2012. The following criteria must be satisfied before an individual is considered for this new policy: came to the United States under the age of 16, has continuously resided in the U.S. for at least 5 years preceding June 15, 2012, and is present in the United States on June 15, 2012, is currently in school or has graduated from high school or has obtained a general education development certificate or is an active member or honorable discharge veteran of the Coast Guard or Armed Forces of the United States, has not been convicted of a felony offense or a significant misdemeanor offense or multiple misdemeanor offenses, or otherwise poses no threat to national security or public safety, and is not older than 30 years of age. The above criteria are to be considered whether or not an individual is already in removal proceedings or is subject to a final order of removal. No individual should receive deferred action unless they first pass a background check and request for relief. Decisions regarding such individuals are to be made on a case-by-case basis. DHS cannot provide any assurances that relief will be granted in all cases. For individuals who are granted deferred action by either ICE or USCIS, USCIS shall accept applications to determine whether these individuals qualify for work authorization during this period of deferred action. Keep in mind that unless an additional deferral period is granted or a path towards legal status is provided by law, deportation will become a threat again. This new policy took effect on August 15, 2012. For more information, you could visit one of the government websites. You could visit either uscis.gov or ice.gov or dhs.gov. Individuals can also call the USCIS hotline at 1-800-375-5283 or ISIS hotline at 1-888-351-4024 during business hours with questions or to request more information about the forthcoming process. Please note that this new policy provides no substantive right, immigration status, or pathways to citizenship. Only the Congress, acting through its legislative authority, can confer these rights. If you have any questions about how this affects you, call us at 718-625-0800 to schedule a free consultation.